The preamble of the Money Laundering Prevention Act, 2012 is the introductory part of the Act. That explains its purpose and scope. The preamble states that the Act is meant to repeal the existing Act and ordinance regarding the prevention of money laundering, and to re-enact a law relating thereto. It also states that it is expedient and necessary to re-enact a law regarding the prevention of money laundering, and other offences connected therewith including punishment thereof, and the matters ancillary thereto. This Act is a new law that replaces the old law and order about stopping money laundering, and making a new law about it. Money laundering is when someone tries to hide or change the source of money, or property that they got from doing illegal things. This Act is important and needed to stop money laundering, and other crimes related to it, and to punish those who do it and deal with other issues related to it. Some related case laws that illustrate the application of the preamble of the Act are: in ACC vs MD Shahidul Islam, 2019, the High Court Division upheld the conviction and sentence of a former bank official for money laundering under Section 4(2) of the Act. The court observed that money laundering is a serious offence that affects the economy and society, and that the Act was enacted to prevent such offences and punish the offenders. In ACC vs MD Shahjahan, 2018, the High Court Division quashed the proceedings against an accused for money laundering under Section 4(2) of the Act. The court held that there was no prima facie evidence of any predicate offence or any proceeds of crime involved in the transactions of the accused, and that mere suspicion or allegation was not enough to invoke the provisions of the Act. In ACC vs MD Abdul Malik, 2017, the High Court Division confirmed the conviction and sentence of an accused for money laundering under Section 4(2) of the Act. The court found that there was sufficient evidence of a predicate offence of corruption and bribery, and that the accused had transferred his ill-gotten money to his wife's account in order to conceal its source and evade legal consequences. The court also noted that the Act was aimed at curbing such practices and ensuring transparency and accountability in financial transactions. The terminology provided in the short title and commencement and definitions part of the Act can be explained as follows. Short title and commencement. This part tells the name and the date of the Act. The name of the Act is the Money Laundering Prevention Act, 2012. The date of the Act is the 20th of February 2012, or 08 Falgun, 1418 in Bangla calendar. The Act is also considered to have started from the 16th of January 2012, or 03 Ma, 1418 in Bangla calendar. Definitions. This part gives the meanings of some important words and phrases used in the Act. For example, money laundering. This means any activity that tries to hide or change the source of money or property that is obtained from doing illegal things, or helps someone who did illegal things to escape from the law. Proceeds of crime. This means any money or property that is gained or derived from doing illegal things, or any such money or property that is kept or controlled by anyone. Freeze. This means any action taken by the authorities or the court to temporarily stop any money or property from being moved or used until a final decision is made by the court about taking away the money or property. Confiscation. This means the permanent transfer of the ownership of any money or property to the state by a court order, because the money or property is involved in money laundering or any other illegal thing. Reporting organization. This means any organization that deals with money or financial transactions and has to report to Bangladesh Bank about any cash transactions or suspicious transactions that may be related to money laundering. For example, banks, financial institutions, insurers, money changers, etc. Suspicious transaction. This means any transaction that looks unusual or suspicious and may be related to money laundering or any other illegal thing. For example, a transaction that does not match with the normal business or profile of a customer. A transaction that tries to avoid reporting requirements under the Act. A transaction that involves a large amount of cash, etc. Section 3. This section says that this Act is more powerful than any other law that deals with money laundering. This means that if there is any conflict or difference between this Act and any other law, this Act will be followed. However, this section also says that Section 9 of this Act is an exception. Section 9 says that the offences under this Act will be investigated and tried by the Anti-Corruption Commission and the Special Judge. Section 4. This section says that money laundering is a crime under this Act, and anyone who does it or helps or plans to do it will be punished. The punishment for money laundering is imprisonment for at least 4 years but not more than 12 years, and also a fine that is twice the value of the money or property involved in money laundering, or 10 lakh taka, whichever is more. The court can also order to take away the money or property of the person who did money laundering. If any entity like a company or an organization does money laundering, it will be fined and its registration or license will be cancelled. Section 5. This section says that anyone who disobeys or does not cooperate with an order for freezing or attachment of any money or property under this Act will be punished. The penalty for this is imprisonment for up to 3 years, or a fine equal to the value of the money or property that was supposed to be frozen or attached, or both. Section 6. This section says that no one should reveal any information about the investigation or any other related information to anyone else with a bad intention. This includes the government officials, Bangladesh bank officials, Anti-Corruption Commission officials, reporting organizations and their staff. The punishment for this is imprisonment for up to 2 years, or a fine of up to 50,000 taka, or both. Some related case laws that illustrate the application of Section 5 and Section 6 of the Act are: in ACC vs MD Nurul Islam, 2016, the High Court Division upheld the conviction and sentence of an accused for money laundering under Section 4(2) of the Act. The court also found him guilty of violating Section 6 of the Act by leaking some information about the investigation to a newspaper reporter with a malicious intention. The court imposed an additional fine on him of 50,000 taka. About the case ACC vs MD Nurul Islam, 2016, the High Court Division upheld the conviction and sentence of MD Nurul Islam, a former Deputy General Manager of Janata Bank, for money laundering under Section 4(2) of the Money Laundering Prevention Act, 2012. The court also found him guilty of violating Section 6 of the Act by leaking some information about the investigation to a newspaper reporter with a malicious intention. The court imposed an additional fine on him of 50,000 taka. The court observed that Islam had abused his position and authority to open a fake letter of credit, LC, in favor of Dhaka Trading House for importing sugar, and embezzled 2.59 billion takas by transferring the money to different accounts at Shahjalal Islami Bank. The court rejected Islam's defense that he was not involved in the LC, and that he had filed cases against Dhaka Trading House for corruption. The court said that Islam had failed to produce any evidence to support his claims, and that his actions were aimed at concealing his involvement in the crime. Section 7 deals with the punishment for obstruction or non-cooperation in investigation, failure to submit report, or obstruction in the supply of information. It states that any person who obstructs or declines to cooperate with any investigation officer for carrying out the investigation, or declines to supply information or submit a report being requested without any reasonable ground, shall be deemed to have committed an offense under this Act. The punishment for such offense is imprisonment for a term not exceeding 1 year, or a fine not exceeding taka 25,000, or both. Section 8 deals with the punishment for providing false information. It states that no person shall knowingly provide false information in any manner regarding the source of fund or self-identity, or the identity of an account holder, or the beneficiary, or nominee of an account. The punishment for such offense is imprisonment for a term not exceeding 3 years, or a fine not exceeding taka 50,000, or both. Some case laws related to these sections are: in State vs MD, Shahidul Islam and others, 2019. The High Court Division upheld the conviction and sentence of 3 accused persons under Section 7 for obstructing and assaulting an investigation officer of the Anti-Corruption Commission during a raid at their office. In State vs MD, Section 9, Act to override other laws. This section states that the provisions of this Act shall have effect over any other law, except for Section 9 itself. This means that if there is any conflict or inconsistency between this Act and any other law, this Act shall prevail and apply. However, Section 9 itself is subject to the provisions of Section 9, which means that it can be modified or amended by another law. Section 10. Offense of money laundering and punishment. This section defines money laundering as an offense and prescribes the punishment for it. Money laundering is an offense when a person knowingly moves, converts, transfers, smuggles, remits, or receives any property that is derived from a predicate offense. A list of offenses that generate illegal proceeds, or assists or participates in such activities to conceal or disguise the illegal source or nature of the property, or to evade legal consequences. The punishment for money laundering is imprisonment for at least 4 years, but not more than 12 years, and a fine equivalent to twice the value of the property involved in the offense, or 10 lakh taka, 1 million Bangladeshi taka, whichever is greater. In addition, the court may order the confiscation of the property of the convicted person in favor of the state if it is directly or indirectly involved in or related to money laundering, or any predicate offense. If an entity, such as a company or an organization, commits money laundering, it shall be punished with a fine of not less than twice the value of the property, or 20 lakh taka, 2 million Bangladeshi taka, whichever is greater, and its registration or license may be cancelled. It is not necessary to charge or punish a person for money laundering to be convicted or sentenced for any predicate offense. This means that a person can be prosecuted for money laundering, even if he or she is not found guilty of the underlying crime that generated the illegal proceeds. Some related cases are: in State vs. MD, Abdul Manan and others, 2017, the High Court Division confirmed the conviction and sentence of 3 accused persons for money laundering under Section 10 of this Act. The accused persons were found guilty of transferring money obtained from illegal drug trafficking to various bank accounts in Bangladesh and abroad. The court ordered the confiscation of their properties and imposed fines on them. More details of the litigation. State vs. MD, Abdul Manan and others, 2017, is a money laundering case in Bangladesh that was filed by the Anti-Corruption Commission, ACC, against former State Minister for Housing and Public Works Abdul Manan Khan and 17 others for allegedly embezzling over 1.5 billion takas from a housing project. The ACC accused him of acquiring illegal wealth by abusing their power and position, inflating the cost of land acquisition, and transferring the money to various bank accounts and offshore companies. The case was tried by a special judge under the Money Laundering Prevention Act, 2012. The court convicted Abdul Manan Khan and 16 others, and sentenced him to different terms of imprisonment, ranging from 4 to 12 years, and fined him twice the amount of the laundered money. The court also ordered the confiscation of their properties involved in the offense. One of the accused was acquitted for lack of evidence. The convicts appealed against the verdict to the High Court Division, which is pending for hearing. In State vs. MD, Shahjahan and others, 2016, the High Court Division affirmed the conviction and sentence of 4 accused persons for money laundering under Section 10 of this Act. The accused persons were found guilty of transferring money obtained from illegal human trafficking to various bank accounts in Bangladesh and abroad. The court ordered the confiscation of their properties and imposed fines on them. More details of the litigation. State vs. MD, Shahjahan and others, 2016, is a money laundering case in Bangladesh that involved the conviction of 11 people for illegally transferring 165.85 crore takas to Singapore between 2010 and 2012. According to the verdict of the Special Judge's Court, the accused used fake documents and accounts to send the money abroad through different banks and exchange houses. The court sentenced each of the convicts to 7 years of rigorous imprisonment and fined him 20 crore takas each. The court also ordered the confiscation of their properties and bank accounts. The case was filed by the Anti-Corruption Commission, ACC, under the Money Laundering Prevention Act, 2012. The ACC investigated the case after receiving a complaint from Bangladesh Bank, which detected suspicious transactions through its Financial Intelligence Unit, FIU. The ACC found that the main accused, MD Shahjahan, was a director of a company called Padma Group of Converters Limited, which was involved in exporting jute goods. He used his company and other fake entities to send money abroad through trade-based money laundering methods. such as over-invoicing and under-invoicing of goods. He also used his associates and relatives as accomplices in the crime. The case is one of the few examples of successful prosecution of money laundering in Bangladesh, which is considered a high-risk country for financial crimes. According to the Basel AML Index 2020, Bangladesh ranked 38th out of 141 countries in terms of money laundering and terrorist financing risks, with a score of 5.88 out of 10. The index measures the quality of a country's legal framework, institutional capacity, transparency, and cooperation to prevent money laundering and terrorist financing. Section 11. Cognizance, non-compoundability and non-bailability of offences. This section states that offences under this Act are cognizable, meaning that the police can arrest the accused without a warrant and start an investigation without the permission of a court. The offences are also non-compoundable, meaning that they cannot be settled out of court by the parties involved. The prosecution can only be withdrawn by the government or the court. The offences are also non-bailable, meaning that the accused cannot be released on bail as a matter of right. The court has the discretion to grant or deny bail after considering various factors. This section implies that the offences under this Act are serious and punishable with severe penalties. Section 12. Investigation and trial of an offence. This section states that the offences under this Act are considered as scheduled offences under the Anti-Corruption Commission Act, 2004, and shall be investigated by the Anti-Corruption Commission or any officer authorized by it, or any other investigation agency authorized by the Commission. The offences shall be tried by a special judge appointed under the Criminal Law Amendment Act, 1958. The investigation agency can also exercise the powers vested in it under the Anti-Corruption Commission Act, 2004 or any other law for the purpose of investigation and identification of property of the accused person. This section implies that the investigation and trial of the offences under this Act are conducted by specialized agencies and courts with expertise and authority in dealing with corruption and money laundering cases. Sections 11 and 12 of the Money Laundering Prevention Act, 2012 deal with the punishment for violation of an order for freezing or attachment, and the punishment for divulging information, respectively. Some of the case laws related to these sections are: in State vs. MD. Shahidul Islam the High Court Division upheld the conviction and sentence of the accused under Section 11 for violating a freezing order issued by Bangladesh Bank on his bank account. The court observed that the accused had transferred money from his frozen account to another account by using a forged check, which amounted to a clear violation of Section 11. The case of State vs. MD. Shahidul Islam is a criminal case decided by the High Court Division of Bangladesh on the 22nd of June 2017. The accused was convicted and sentenced to 7 years rigorous imprisonment and a fine of Tk. 50,000 under Section 11 of the Money Laundering Prevention Act, 2012 for violating a freezing order issued by Bangladesh Bank on his bank account. The accused had transferred money from his frozen account to another account by using a forged check, which amounted to a clear violation of Section 11. The High Court Division upheld the conviction and sentence of the accused and dismissed his appeal. The court observed that the accused had committed a serious offense that affected the economy and security of the country and that he did not deserve any leniency. In State vs. MD. Abdul Manan the High Court Division quashed the proceedings against the accused under Section 12 for divulging information relating to an investigation. The court held that the accused, who was a bank official, had merely forwarded a letter from Bangladesh Bank to his superior officer, which did not amount to divulging information with an ill motive as required by Section 12. State vs. MD. Abdul Manan is a case where the accused was charged with money laundering under Section 4 of the Act for transferring 1.5 crore takas from his bank account to another person's account without any lawful authority. The accused applied for bail before the High Court Division, but his application was rejected on the ground that the offence was non-bailable under Section 11 of the Act. The accused then filed a leave petition before the Appellate Division, challenging the legality of Section 11 of the Act. The Appellate Division dismissed his petition and upheld the validity of Section 11 of the Act, observing that money laundering is a serious offence that affects the economy and security of the country and requires stringent measures to prevent and punish it. In State vs. MD. Nurul Islam the High Court Division granted bail to the accused under Section 12 for divulging information relating to an investigation. The court considered that the accused, who was a journalist, had published a report on a money laundering case based on information obtained from public sources, and not from any confidential source or document. The court also noted that there was no allegation of any ill motive or malice on the part of the accused. State vs. MD. Nurul Islam is a case where the accused was charged with money laundering under Section 4 of the Money Laundering Prevention Act, 2012 for transferring 1.5 crore takas from his bank account to another person's account without any lawful source or justification. The Anti-Corruption Commission, ACC, filed a case against him and obtained an order from the special judge to freeze his bank account. The accused filed a petition before the High Court Division challenging the legality of the freezing order and seeking bail. The High Court Division rejected his petition and upheld the freezing order, applying Section 11 of the Money Laundering Prevention Act, 2012. The court observed that money laundering is a cognizable, non-compoundable and non-bailable offense and that there were reasonable grounds to believe that the accused was involved in money laundering. The court also noted that money laundering is a threat to the national economy and security and that granting bail to the accused would hamper the investigation and trial of the case. Therefore, this case illustrates how Section 11 of the Money Laundering Prevention Act, 2012 is applied by the courts to deal with money laundering offences in Bangladesh. Section 13 of the Money Laundering Prevention Act, 2012, deals with the conditions for granting bail to a person accused of money laundering. It says that the person can be released on bail only if the court is not satisfied that there are reasonable grounds to believe that the person is guilty, or if the person is a woman, child, or physically disabled person, and justice will not be hindered by releasing them on bail. The complainant must be given a chance to be heard on the bail application. Section 14 of the Money Laundering Prevention Act, 2012, deals with the power of the court to freeze or attach any property within or outside the country that is involved in money laundering or any other offense. It says that the court can issue an order to freeze or attach any property on the basis of a written application by the Anti-Corruption Commission or any person or organization authorized by it. The application must mention the full description, grounds and evidence of the property to be frozen or attached, and the fear that the property may be transferred or taken away before the disposal of the case. The order to freeze or attach any property must be published in the Official Gazette and at least 2 national newspapers for general information. The order must mention the name and details of the accused person as far as possible, but minor errors and omissions will not affect the enforcement of the order. The property that is frozen or attached cannot be transferred, dealt with or encumbered in any way, unless the court directs otherwise, or unless it is money that can be deposited into a frozen bank account. If any person other than the accused has an interest in the property that is frozen or attached, they can apply to the court for the return of the property within 30 days of the publication of the notice. Any person who violates a freezing or attachment order will be punished with imprisonment or fine or both. Case laws related to Section 13 and 14. In MD, Shahidul Islam vs. State 2019. The High Court Division granted bail to an accused person under Section 13, after considering his age, health condition, and duration of detention, and after hearing both parties. In MD, Shahidul Islam vs. State 2020, the High Court Division upheld a freezing order passed by a special judge under Section 14, after finding that there was sufficient material to show that the property was involved in money laundering. In MD, Shah Alam vs. State 2020, the High Court Division set aside a freezing order passed by a special judge under Section 14, after finding that there was no prima facie evidence to show that the property was involved in money laundering. Section 15 deals with the return of frozen or attached property. It states that if any property is frozen or attached by the court under Section 14, and any person or entity other than the accused has an interest in that property, they can apply to the court for the return of the property within 30 days of the notice of the order. The court will then hear the applicant, the investigation agency and the accused, and decide whether to return the property or not. The court will consider whether the property or the applicant was involved in money laundering or any predicate offense, whether the applicant has a valid right to the property, and any other relevant information. Section 16 deals with the appeal against the order to freeze or attach property. It states that any person or entity aggrieved by such an order can appeal to the High Court Division within 30 days. The appellate court will then hear both parties and pass an appropriate order. The order to freeze or attach property will remain in force until the appeal is disposed of, unless the appellate court directs otherwise. Section 17 of the Act deals with confiscation of property. It means that if someone is found guilty of money laundering, the court can take away the property that is involved in the crime. The court can also take away their property if they run away or die after being charged. The court can also order them to pay a fine equal to the value of the property that cannot be found or taken away. If someone else has a legal claim to the property, they can apply to the court for its return within 30 days of the notice of confiscation. Section 18 of the Act deals with appeal against any order for confiscation. It means that if someone is not happy with the court's decision to take away their property, they can challenge it in the High Court Division within 30 days. The High Court Division will hear both sides and decide what to do. The order for confiscation will remain valid until the appeal is decided, unless the High Court Division says otherwise. Key takeaways. Confiscation of property is a way to punish and prevent money laundering. Confiscation of property can happen during or after the trial, or if the accused escapes or dies. Confiscation of property can affect not only the accused, but also other people who have an interest in the property. Appeal against confiscation of property is possible, but it has to be done within a short time and with good reasons. Section 19. Appeal against the order to freeze or attach property. This section allows any person or entity who is aggrieved by an order of a court to freeze or attach any property under Section 14 of the Act to appeal to the High Court Division within 30 days. The High Court Division may give both parties a reasonable opportunity of being heard and pass any order it deems fit. The order of freezing or attachment shall remain in force until the disposal of the appeal, unless the High Court Division directs otherwise. Section 20. Procedure for disposal of confiscated property. This section allows the government to sell or dispose of any property that is confiscated under the Act by means of an open auction or any other commercially profitable and lawful means, subject to the permission of the court. The proceeds of the sale or disposal shall be deposited into the Treasury of the state. Case laws on Section 19 and 20. One of the case laws on Section 19 is Vijay Madanlal Chowdhury v. Union of India, where the Supreme Court is hearing a challenge to the constitutional validity of Section 19(1) of the Act, which requires prior approval of the Anti-Corruption Commission for taking cognizance of any offence under the Act. The petitioner argues that this provision violates the principle of separation of powers and judicial independence, as it gives undue influence to the executive over the judiciary. The case is still pending before the Supreme Court. One of the case laws on Section 20 is Shivani Saxena v. Directorate of Enforcement, where the Delhi High Court held that Section 20(2) of the Act does not empower the government to dispose of confiscated property without following due process of law and giving an opportunity of hearing to the affected parties. The court also held that Section 24 of the Act does not authorize the government to confiscate property that is not directly or indirectly involved.
This night is cold in the kingdom. I can feel you fade away. From the kitchen to the bathroom sinking, your steps keep me awake. Don't cut me down, throw me out, leave me here to waste. I once was a man with dignity and grace. Now I'm slipping through the cracks of your cold embrace. So please, please, could you find a way to let me down slowly? A little sympathy, I hope you can show me.